Hi, Benjamin Jaffe with SQ Law. We've talked a little bit about minors being charged in sexual abuse or sexual cases, criminal cases, and the idea that a minor can be charged with any crime that an adult, or most any crime that an adult can be charged with. But one of the specific questions we get in that regard is, how does a court determine if a minor should be charged as an adult? So first of all, the court does not make a determination as to whether a child will be charged as an adult. That is an assessment made by a prosecutor's office and whether they will file those charges. And so once a court is presented with charges, their only real question is there justification for the charges, and that is there probable cause for this case to go forward. So really it's a assessment by a prosecutor's office and by investigators who have input and or other individuals within the system that have input as to whether things should be charged. Now, with that being said, we oftentimes deal with cases where there are assessments of, allegations in either sexual abuse or other charges that aren't even sexually related as they pertain to minors. And there will be an assessment by it's a probation office is generally doing the assessment. And there is a preliminary inquiry, is what they call it, into the situation. So let's just say there's an allegation that a crime occurred. There will be that preliminary inquiry that will develop factors or develop information about the situation and or the child to decide if something should be charged. It is not uncommon for us to be in situations as attorneys where we are able to have a big impact on whether or not charges are filed in juvenile court. In fact, I would say that in most cases, we are able to avoid charges being filed, or at least a good portion of our cases. Because we get things done, or we have some things done proactively to prepare for those things. And obviously, the less serious the situation is, the less, violent the case is, the less, high level the charges are, the more likelihood it will be developed, or assessed informally or dealt with informally. And so we'll often have situations where a crime did in fact occur that could be charged, but because the child has either done some things to prepare themselves by, maybe being in counseling or getting in some classes or something like that, or demonstrating that their behavior is very different. Oftentimes we get information on we'll have a child that is autistic or special education or something. We get that information to the prosecutor, and they're able to assess things from a different point of view or a different perspective because now they have more information. And so I'm not saying those are the only situations that can help, but there's always things that can be done to help the situation. And it is almost always considered by the state as to whether or not they should file charges. Again, the lower the level the charges. If I have something very minor, like a child who is, let's just say truant, they have been missing school a lot, such that it's actually being looked at as a potential crime, or the child is out past curfew or something, like some kind of minor violation that could be charged. Those things can be assessed. And if the child's back on track, they're now doing well in school, maybe they've gotten in some counseling or gotten back on their medication, we've been able to demonstrate, hey, this shouldn't be charged, and it is dealt with informally. I've had situations like shoplift or something like that, fairly minor, but, that's something you don't want your child involved in and certainly could be charged criminally. Those things are assessed. Is this child back on track? Are things going well? Are they behaving at home? And oftentimes there's an assessment of that, and there's the ability for maybe the kid to take some classes or, be in some kind of therapy or something like that to show that they're on track or demonstrate that they're on a very different track. And it obviates the need for charges to be filed. Obviously, the more serious the charge, if it's a violent offense or something along those lines, and if we're talking about sexual offenses, the more serious the sexual offense, the more likely it is to be charged. But again, that's an assessment by the prosecutor, not the courts. And oftentimes because of that, there's also the ability, even after something's been charged, to come to some agreement or to have some kind of, resolution to the case that excludes a conviction. And so oftentimes when things are charged, I have the ability to negotiate for my client to complete some services, to do some things to demonstrate their compliance, show that they're doing very well and have gotten back on the right track. And I've had the state willingly dismiss the case because of that, because they really don't want to seek a conviction. I'm not saying that's all the time, but there are definitely ways to affect things, even if charges have been filed, that once they're filed. And then even beyond that, if there is a conviction in a juvenile court, a true finding is what it would be called, there's still ways to affect that. Oftentimes I've had courts do a conditional type of situation where they'll make a certain finding and they'll have them complete some conditions and they'll go back and make some changes. And so there's a lot of things that can be done in juvenile court, a lot more flexibility than adult court. So even if charges have been filed by the state, they've been approved by a judge as being, there's probable cause, there's still ways to impact things. And it's one of the things I like about juvenile court. There's a lot of ways to help kids get on the right track if they're willing to. I guess the worse things are overall, the more difficult it makes it. So if I have a kid who's committing a criminal act, but he's also not going to school or doing very poorly in school, and he's also taken off from home and the parents don't know where he is a lot of times, and he's also using drugs, that's going to be a much more challenging road. Now, it does provide opportunities to get a lot of things back on track. So if I can affect those things, it can lead to a better outcome. But in general, if we have a kid that's going to school, doing well, listening to his parents, or has changed and now he's doing those things better, he or she, oftentimes that's going to give us a lot better options. So that's kind of a long-winded answer, and it goes into a lot of things, but these are things that, parents are concerned about. We get a lot of calls where parents are thinking a kid's ruined their lives because they have some kind of allegation as a child. That is far from the truth. There are lots of options to help children, help minors, especially if it's a relatively low-level offense. So please give us a call if something like that comes up, if there's an investigation going on, because a lot can be done to help your child and to keep them from having something that falls into adulthood.